We've all been doing it tough with COVID-19, and small business in particular has been affected when you consider the opening, the closing, the opening, and all the restrictions that have been placed on small business in order to be able to function. They have been hit hard, and of course Shellharbour City Council is really pleased to partner with the Illawarra Business Chamber to run webinars that will give advice to small businesses.
I'm here with David Potts, who's a partner at Kells in Shellharbour and the head of their employment, personal injury and compensation teams. Welcome, David, and thanks for being with us.
My pleasure. Thank you very much.
David, it's been an exceptionally challenging time, as we all know, for not only the country but here in our region in the Illawarra. What have your clients been particularly experiencing throughout the pandemic, and what have you been advising them?
It's been a challenging time for everyone. The initial challenges were quite different from the challenges people face now. The first set of challenges related largely to uncertainty. People weren't sure about the duration and the effect of the virus upon us. And at that stage, there weren't as many measures in place designed to help businesses. So the first set of challenges related to issues about stand downs, and whether it was lawful for organisations to stand employees down, and that's evolved over time. It's involved with the introduction of the JobKeeper allowance. It's involved as people and businesses have looked at their situation. We're probably more optimistic now than we are about the future than we were in those early days of March and April.
Following from that, have there been any major changes to either the legislation or, I guess, the principles governing employment law at the moment?
The legal system has responded rapidly to the challenges faced by the COVID-19 virus. One of the most interesting changes was the introduction of JobKeeper enabling directions, and they came into force in the Fair Work Act on the 9th of April. They enable employers, with consultation with their employees, to change conditions both as to hours, places of work, and in some circumstances to stand employees down. So that was a major change, and it was a change that was designed to give effect to the JobKeeper allowance. So hand in hand with the JobKeeper allowance being introduced by the federal government, there was a direction ability which was introduced, which was designed to give employers and employees to a degree some increased flexibility. So that was a radical change to the law, because until that point, employers had no automatic right to change people's contract of employment. So the JobKeeper enabling directions gave a great degree of flexibility to that relationship.
So redundancy and stand downs, of course, are two principles that have been discussed openly in the media. Could you just give us an idea of what the difference between the two is?
A stand down is a direction by an employer that he no longer wishes the employer to turn up for work. They're stood down from their employment. There's a long history behind that. Traditionally, stand downs used to take place during industrial disputes when there was no useful work for a worker to do. In the COVID-19 pandemic, there were some industries which, as you know, ceased basically to operate. So if you think of the restaurants and if you think of pubs in those circumstances, they simply couldn't trade. So in those circumstances, it was certainly lawful for there to be a stand out, but that's been introduced into the response that society and employers have had. If you can contrast that to a redundancy, so a redundancy is when an employer determines that it no longer wishes a position to be done by anyone, and provided they go through certain steps, that termination of employment can be perfectly lawful. So there are two different responses. So a stand down is where someone maintains the employment relationship although they are not physically working at that time, and that can also be achieved through a JobKeeper enabling direction, or alternatively, termination of a contract of employment, which can be done by way of a redundancy. One of the great impetuses that the federal government have put behind the response that we have had to the virus is to try to keep people engaged and employed. So a stand down is one way that that can be facilitated. A redundancy is the end of the relationship. So there are two different responses which businesses can look towards.
And I would have thought a redundancy would be very much a last ditch, effort by an employer to sort of, I guess, if they're wrapping up a certain area of their operations because they don't see an immediate future through the pandemic, or they can't continue in that vein for financial reasons.
Redundancy is in fact the termination of a contract of employment. So because of that is obviously only the final step that someone would take. So if you're uncertain as to what the future would hold, moving to a redundancy may be premature. And if you have other responses which you could have in your arsenal, including a JobKeeper enabling direction, they could well be preferable. So that redundancy is a bit like the Phantom Agents used to say, a last resort. It's something that should only be done in circumstances where you can't envisage any future for that position.
Do you think that JobKeeper has actually put off a lot of redundancy talk in favour of some lighter touch options that have allowed employers to keep the relationship with their employee? Because that was certainly the intention as described by the federal government.
The scheme was designed for that very purpose, and it has achieved a great degree of retention of people in their employment in a variety of different ways. The experience of my clients has been that it's been invaluable in terms of keeping people on the books and hopefully ready to return to work.
David, could you give us a little bit more information about what the requirements are for a business to be able to use these JobKeeper enabling directions?
The JobKeeper enabling directions have three principal requirements. The first is there's a notification requirement that you have to notify your employees that you're going down that path. The second is a consultation process whereby you have to talk to your employees about what you're proposing. And the third is you have to provide a written direction as to what it is. There can be circumstances where an employee can challenge the reasonableness of the direction, and the Fair Work Commission has a jurisdiction to consider those challenges. There's been very few cases determined yet, but of the three cases which I've seen, two have supported the employer in that the employer's been acting reasonably, one hasn't. So that there's a process. The process is different to other processes. If you didn't have the JobKeeping enabling direction, you would have to secure the employee's consent to a fundamental change in the contract of employment. This doesn't require an employee's consent. It requires notification, consultation, and a written form of direction. And if the employee is still dissatisfied with that, there's a right of challenge to the Fair Work Commission.
Okay, so obviously an employer would need to be a current recipient of JobKeeper.
Yes.
For a start. Are there any other major general guidelines that apply when it comes to receiving one of these directions?
The principal requirement is, as you've said, you need to be eligible for JobKeeper. If you're not eligible for JobKeeper, you can't have a JobKeeper enabling direction. The other requirement is the direction needs to be reasonable. As I said a little while ago, you can actually require people to go to different places of employment. But again, that's going to be a question of reasonableness. You couldn't require someone who works in Shellharbour to suddenly work in the North Shore of Sydney. So it becomes reasonable. What is reasonable in those circumstances?
Obviously, a lot of employers, unfortunately, may need to still look at redundancies despite what you've said. Can you first explain to us what is a genuine redundancy?
There are three elements. The first element is that an employer determines that it no longer wishes a position to be done by anyone, generally due to changes. The second is that if it is required under an industrial instrument, which is generally a modern award, they consult with the employee before a final decision is made. And the third is that it's not reasonable to redeploy them to another position in the organisation.
There will be some businesses that will go through probably a sustained decline and they may make some redundancies, but at the end of that process, and hopefully once coming out of the pandemic, there'll be some businesses that are better positioned. What are the requirements about them recruiting people back into those roles that they'd previously made redundant?
It's difficult to recruit someone back into a role that was previously made redundant because the employer had determined that it no longer wishes that position. So the key element is focusing on a position. It doesn't want the position to be formed or doesn't need the position to be performed by anyone. So it's difficult to refill a position in those circumstances. However, if there were new positions, if there were different roles, it would be easier to fill into those different roles. So if you make a determination that you don't need a receptionist in an organisation for whatever reason, it would be difficult to fill that role as a receptionist. But if you need other roles in the back office, easy enough to fill those. So that one of the keys would be, it would be not something that would be easy to do, particularly if there was only a short gap between someone being made redundant because their position is no longer required and someone being rehired.
Is any of that contingent on the businesses obviously shrinking through the pandemic, and then once they start growing again?
There could be good examples of that. So if you had a particular business that had a branch office at Oak Flats, and for particular reasons they determined to shut that branch office, and then when trading conditions improved, they wished to open that office again, that would be a good example of being able to fill a position that was previously made redundant. But if you're dealing with the same operation, those issues are a little more difficult.
Okay, so David, we've seen how through the pandemic restrictions have mounted up and become more severe and clamped down businesses in a lot of different sectors, and now of course they're starting to ease again, and we hope that that continues to be the case. What would be your advice to employers as they start recruitment processes, hopefully to rehire people or to grow their businesses as we start to emerge from the pandemic?
And the first piece of advice is that for many industries and businesses, people are the key drivers. The more effort that you put into your recruitment process, the better will be your business. So it is something that needs time and consideration. The first starting point is to have a good, accurate job description for that particular position. The second is to know what you need to fill it. The third is to go through a process. Now the process will vary depending upon the position, but to go through a process that is fair to all applicants, and a process which is considers all applicants for that position who are suitable. Two key aspects are to check references. Many times employees will provide references, and if they do, you should always speak to those references or referees, because they can provide detail about the employee, and you should ask them hard questions. You should ask them why they left, what were their weaknesses, what problems did they have, how did they relate to people in the organisation, and a good checklist to do that is useful. The second thing is to check gaps. So if you're given a resume, you should always look at that critically. You shouldn't just think, oh, you should look for gaps, and you should look for dates as to when people completed particular requirements. In a nutshell, but the more effort you put into your recruitment process, the better will be the results for the new staff that you hire. Because as we expect, Adam, in the spring and in summer, businesses will be returning, there'll be much more work, there'll be a need to hire. I'd just be cautious about putting effort into that process and making sure that you develop sufficient resources to give it sufficient impetus, because it's a very important step.
I'm really hoping that that all happens and that, you know, as you say, coming spring and summer, we'll be looking at growth in the economy, lots more people going back into jobs and meaningful work. But for the time being, thanks so much for your advice today, David, and for making the time to be with us.
My pleasure. Thank you very much.
I'd like to thank Shellharbour City Council for sponsoring today's webinar. Thanks also to Relativity, our content partner, and please get in touch with us at the Illawarra Business Chamber if we can ever be of support or assistance.